Welcome all, and I hope everyone is sitting back, relaxed in front of their computer and at home or wherever you are, as the case may be, because tonight's presentation is very special with two special participants. We entitled it The Enduring Legacy of John Jay, and we know that among the first rank of our founders, we think of Jefferson, Washington, Hamilton, Adams, and the like. John Jay, sometimes less so, but we in this coterie here think that John Jay deserves to be in the first rank, and we, our participants, I think, are going to aim to prove that tonight. So welcome to this event. It's sponsored by the Historical Society of the New York Courts. I'm Albert Rosenblatt. I'm a moderator here tonight, which means I may be chipping in every now and then, but the two participants are special, and I'll get to that in a moment. The program is sponsored by Proskauer Rose. It's part of the Stephen K. Memorial Program Series, and we're going to open up the program with some recorded remarks from the Chief Judge of New York, the Honorable Janet DiFiore.
Good evening and welcome to tonight's program, The Enduring Legacy of John Jay. This year marks the 175th anniversary of the New York Court of Appeals, and I am so very pleased that the Historical Society is sponsoring this program to explore the extraordinary legacy and accomplishments of New York's first Chief Judge, John Jay, who led our state's High Court from 1777 through 1778, before the court was reorganized as the Court of Appeals in our state's Constitution in 1846. Anyone who has argued an appeal or has had occasion to visit our beautiful courtroom inside Court of Appeals Hall can't help but notice the large, impressive portrait that hangs behind our bench directly above the Chief Judge's center chair. It's the portrait of John Jay, whose place in the history of our state and our nation I had only a passing knowledge of until November 15th, 2018. That was the date on which, thanks in part to the good offices of former Court of Appeals Judge Al Rosenblatt, my colleagues and I traveled to the Ulster County Courthouse in Kingston, New York, to hear oral argument on the very site where John Jay presided over the first sitting of New York's High Court in 1777. And on that date, along with over 100 high school and college students, we were treated to a number of lectures and historic exhibits on John Jay, including an original draft in Jay's own handwriting of New York's first Constitution. A few weeks after our visit to Ulster County, I had the opportunity to read the manuscript of an excellent new book on John Jay, authored by my former colleague in the Westchester County District Attorney's Office, now Associate Justice, sitting on the Appellate Division's Second Department, Mark Dillon. Justice Dillon's work further informed me, and so having come to more fully appreciate this remarkable founding father, who was the principal author of the New York State Constitution, first Chief Judge of New York State, President of the Second Continental Congress, author of several Federalist papers, and President George Washington's selection as our nation's first Chief Justice, I can assure you that you're going to enjoy this wonderful program, a program featuring distinguished lawyer turned acclaimed biographer Walter Starr, whose comprehensive and entertaining biography of Jay depicts a fascinating individual who was not only an exceptional judge, diplomat, and chief executive, but a truly dedicated public servant who time and again accepted positions in service to his country at great personal, professional, and financial sacrifice. And Mr. Starr is joined by Justice Dillon, whose book focuses on Jay's jurisprudence and leadership at the Supreme Court, perspectives that are informed by the judge's 25 years of excellent service on our state's appellate and trial benches. And to moderate the discussion between these renowned Jay scholars is Judge Al Rosenblatt, who has been a most devoted supporter and friend to the Historical Society since it was created 20 years ago in order to preserve and promote the rich history of the New York State courts. So thank you to our presenters for their participation this evening, and thank you to the Historical Society for always delivering interesting and enlightening programs that highlight the history of our courts. And we are especially appreciative of the time, care, and attention devoted to the Society by its dynamic president, Jonathan Lippman, the dedicated board members, and the Society's executive director, Marilyn Marcus, and her terrific staff. And of course, thank you to all of you for tuning in this evening and for all that you do on a year-round basis to support the work and the mission of the Historical Society of the New York State Courts. I hope you enjoy the program.
Thank you, Chief. We're off to a great start, and we're soon going to be hearing from two scholars, the two scholars who have written important books about John Jay. We'll be hearing from the Honorable Mark C. Dillon. He's the author of The First Chief Justice, John Jay and the Struggle of a New Nation, which was published earlier this year. Justice Dillon currently sits on the Appellate Division, Second Department, after having served as New York Supreme Court Justice and Westchester County Court Judge. Justice Dillon also teaches at Fordham Law School, where he earned his JD. We'll also be hearing from another scholar, Walter Starr. He's the author of John Jay, Founding Father, published in 2005. He's currently counsel to EMP Global after having served as counsel for Fidelity Investments and the U.S. Securities and Exchange Commission. Walter earned his JD from Harvard. P.S. Walter mentioned to me the other day that his father was a member of the class of 1960 and asked whether I might have been in that class, and I indeed was. So Walter's father and I were classmates, which just adds just a little bit of flavor for me to this evening. All you listeners should know that both books are available for purchase wherever books are sold. So we'll first hear from Walter Starr, who will discuss John Jay's early years and his accomplishments before he assumes the bench, about his personal and his professional life. Walter.
Thank you, Judge Rosenblatt. So as he's just said, I'm going to start with his birth, and I'm actually going to give a little bit beyond the Supreme Court. So you get I'm going to leave to Judge Dillon the Supreme Court years. So Jay was born in New York City, south of Wall Street, which is where the city essentially ended, in 1745. Not long after his birth, however, the family moved out to Rye because two of his siblings had been blinded by smallpox, and his parents wanted them to grow up out in the country. Jay himself returned to the city in 1760 to enroll at King's College, the predecessor of Columbia University, which at the time was a small religious school headed by an Anglican minister. Upon graduation, Jay apprenticed himself to a leading lawyer in New York City, and 4 years later, he was admitted to the bar. By 1774, although young, he was one of the leading lawyers of New York City. That was the year in which he married Sarah Livingston, the intelligent, beautiful, sociable daughter of William Livingston, another leading lawyer, although recently retired. If there had been no revolution, no constitutional crisis, Jay would, I think, have lived the quiet life of a successful lawyer. But a few months after his marriage, he was named to a committee to consider how New York should respond to the new British laws, which were aimed at punishing Massachusetts for the Boston Tea Party. In the fall of that year, he was elected a delegate to the Continental Congress. He traveled to Philadelphia, where he worked with George Washington, John Adams, and others on the response to the British laws. He was back in Philadelphia the next year, spent much of that year in Philadelphia, again part of the Continental Congress, drafting important papers and meeting, among others, Benjamin Franklin and Thomas Jefferson, two others who would play important roles in his life. By the summer of 1776, however, he was back in New York, serving as a member of the Provincial Congress. Among other things, he was on a committee to detect and interrogate suspected British spies. He worked in that role, among others, with Enoch Crosby, the prototype of the title character of James Fenimore Cooper's novel, The Spy. Almost 40 years later, Jay talked with his neighbor Cooper about Crosby and other events, and thus provided the raw material for the novelist. When the text of the Declaration of Independence arrived in White Plains, which is where the Congress was meeting because the British fleet had arrived in New York Harbor, it was Jay who drafted the official response, saying that, quote, "While we lament the cruel necessity which has rendered the declaration unavoidable, they approved the declaration and would, at the risk of our lives and fortunes, join with the other colonies in supporting it." These were not mere flowery words. If the revolution had gone the other way, if the British had won, Jay might well have been tried for treason and executed. Jay was the principal author of the first state constitution of New York. He and others worked on the project for several months, and it was Jay who prepared the clean draft that was presented to the convention in early 1777. He was away for the last few weeks of the process, however, after the death of his mother, so he read the final document in the newspapers. He immediately objected to some friends about a couple of provisions, including one that allowed judges to appoint their own clerks, which he feared would lead to nepotism, and one that required lawyers to qualify in each of the county courts rather than before one single court, which he feared would be burdensome. He assured his friends, however, that he would do everything he could to nurse and keep the Constitution alive like a small child that needed the assistance of its parents. After adopting the Constitution, the convention named Jay as first Chief Justice of the state. There was some talk about whether he should run for governor, but he discouraged this, saying that he thought he could be more useful as a judge than as a governor. In all, fewer than 4,000 men voted in the first state election for governor, which highlights a critical point. The state at this time consisted of only a few counties along the Hudson River. There was a rival government, the British government, in New York City that claimed to control the entire colony. It was rather like some South American revolutionary situation with two rival governments and many ordinary folks caught in the crossfire. So as we heard from Chief Judge DiFiore, it was Jay who presided over the first session of what was called the State Supreme Court. The vocabulary has shifted, in Kingston, New York. Again, you should not think of the elegant building now occupied by the Court of Appeals in Albany. You should think of a modest stone structure, which indeed, not long after that session, was attacked and badly damaged by the British. As was the custom, he started the session with a lengthy charge to the grand jury, soon published in the newspapers. He analogized the new state constitution to Adam and Eve before their maker gave them life. The Constitution was waiting, he said, for the breath of life from the people of the state. From them it must receive its spirit, by them be quickened. Let virtue, honor, the love of liberty and of science be and remain the soul of the Constitution, and it will become a source of great and extensive happiness to this and future generations. Jay presided over several sessions of the state Supreme Court, but he didn't leave behind major published opinions in this role. We know enough to say that he was a serious, competent judge, but he wasn't a state judge for very long, because in late 1778, the the state sent him back to Philadelphia once again to serve in the National Congress. And within a few days of his return, he was elected president of the Continental Congress. You know, when we see that word president, we think of the helicopters and all the panoply of our current president. But the president of the Continental Congress was a very different animal. His principal duty was just to preside over the sessions of Congress, a bit like the mayor of a small town selected to preside for a year over the city council. The president generally didn't participate in the debates, but before each important vote, he would summarize the issue for the members, a bit like a judge summing up for a jury. I argue in my book that his most important relationship was not with the other members of Congress or with the French or Spanish diplomats with whom he had to deal in Philadelphia, but with General George Washington. The general was a decade older than Jay. He was already famed, even revered. But in another sense, he was merely a general who reported to the Continental Congress represented by its president, Jay. They spent a bit of time together because Washington was in Philadelphia, but they spent much more time apart. And from a biographer's perspective, that's beautiful because we have all their letters. Most of these were official, but some were more personal and informal, such as when Jay complained to Washington that he could not get Congress to focus on the rapidly depreciating continental currency. There is as much intrigue in this state house, he wrote, as in the Vatican, but as little secrecy as in a boarding school. And I guess because I went to a boarding school, I've always loved that quote. After less than a year, Jay received another important assignment. Congress sent him to Spain to negotiate there for recognition and financial support. His wife, Sarah, decided that she would accompany him to Spain, leaving their 3-year-old son with her family in northern New Jersey. She almost paid for her decision with her life when their ship was dismasted and badly damaged in the North Atlantic. And she wrote to her parents that although they admired her husband, they were not acquainted with half his worth. It is the property of a diamond to appear most brilliant in the dark, and surely a good man never shines to greater advantage than in the gloomy hour of adversity. The ship limped into Martinique, from which the Jays took a French warship heading for Toulon, which was itself nearly captured, but managed to reach Cadiz on the Atlantic coast of Spain. They stayed there for a while, knowing that the Spanish government might not want him to go to Madrid, and they were finally told that they were allowed to proceed as private citizens. They started armed with everything that they needed by way of food and even bedding, but Sarah realized at the first inn that she had forgotten a key item, a broom to sweep the room of dust and bugs. She wrote home to her parents that, judging by the number that remained, there must have been thousands in the room before they started sweeping. The Jays spent 2 difficult years in Spain, and Jay achieved essentially none of his diplomatic goals. Spain did not recognize the United States, it did not enter into a treaty with the United States, and it provided him with only paltry financial aid. While he was there, Congress named him as one of 5 members of a commission to negotiate peace terms with Britain, the others being Franklin, Adams, Jefferson, and Henry Laurens of South Carolina. And in early 1782, Franklin wrote to summon Jay to Paris because peace talks were about to start. Jefferson stayed in Virginia and did not serve at all on this peace commission, and Laurens only showed up for the last few days of the negotiation. The American team was composed of Franklin, Jay, and Adams. One of Jay's key roles was making and keeping the peace between Franklin and Adams, who did not like one another. Another key role was drafting and redrafting the peace terms. Like every good lawyer, he wanted to prepare the first draft. And he was a key player in devising the boundaries, which defined the eastern United States more or less as we know it today, up to the Great Lakes, out to the Mississippi River. both at the time and since, people have recognized this as one of the great diplomatic successes of America's history. When he returned to New York City in July of 1784, he learned that he had yet another important assignment. He was Secretary for Foreign Affairs. This was another difficult assignment. The United States didn't have any navy and army, and so Jay could make arguments with France and Britain about various points, but couldn't really accomplish very much. Perhaps his most important work in this period was advocating for the creation of a stronger federal constitution. He started this almost immediately in conversation with members of Congress. He continued through the Philadelphia Convention and the publication of the Federalist Letters, in which he collaborated with Madison and Hamilton, and then perhaps above all at the Poughkeepsie Convention, when New York barely ratified the Constitution. Indeed, I argue that New York probably would not have ratified the Constitution without a letter which Jay drafted, in which the delegates explained that the only reason they were approving the Constitution was that they were confident that other states would soon agree to amendments to the Constitution to correct what the opponents saw as serious flaws. Jay and the other proponents of the Constitution agreed in this side letter or circular letter that they would work with the opponents to develop and ratify these amendments, in essence, what we call the Bill of Rights. As Washington considered in early 1789 who to name to the Supreme Court, he quite quickly settled on John Jay as Chief Justice. There were other candidates, including others who had more judicial service, but Washington was keen to find someone with a broad resume and reputation, and Jay was exactly that person, as Madison wrote to Washington. Indeed, at this point in our history, Jay was far better known, far more respected than either Madison or Hamilton. There was no opposition to Jay's nomination in the Senate, indeed none to any of Washington's nominations for the High Court. Judge Dillon's going to talk about his work on the US Supreme Court, but let me say a word or two about his last year on the court, which he spent abroad on diplomatic assignment. In the spring of 1794, it seemed like the US and Great Britain were headed towards war, a war we were utterly unprepared to fight, and Washington wanted to send someone to London to negotiate a peace treaty. Again, he turned to Jay because of his strong national reputation as well as his diplomatic experience. This time there was opposition in the Senate, including arguments that it was improper to send a sitting justice on a diplomatic assignment. But the nomination was approved, and Jay gets on a boat in May of 1794, heads to England, negotiates for several months with the British foreign minister, and signs what we call Jay's Treaty. It was not perfect. There was one provision about trade with the Caribbean, which was ill-advised. But Jay was 3,000 miles away with no staff, no way of sharing drafts or getting guidance from the rest of the national government. Rather than sail home immediately, he decided to wait, in part because of the weather, in part because he thought that President Washington might, when he saw the signed agreement, instruct him to attempt to revise a few points. But receiving no further instructions, he sailed for home in the spring and reached New York in May. He was somewhat surprised to learn when he returned that he was a candidate for governor. Indeed, the early returns suggested that he would be elected. And he was also somewhat surprised to learn that although people knew that a treaty had been signed, they didn't know what it said. So he has this curious experience. He simultaneously is elected governor, resigns from the Supreme Court, and then the terms of the treaty are leaked and all hell breaks loose. There's a firestorm of protest. He's burned in effigy. He's accused of taking bribes from the British. Every provision of the treaty was reviewed and attacked. My view is that this wasn't really very much about the terms of the treaty. It was outrage at the very idea of a treaty with Britain, with which, after all, we had just fought our war of independence. After some debate, the Senate ratified the treaty on condition that one provision be revised, to which the British agreed. Jay takes up his duties as governor of New York. He governs capably from July of 1795 through June of 1901. He probably could have secured a third term, but he wanted to retire, and he did retire to his farm in Westchester. Unfortunately, his wife dies not long thereafter in May of 1802. So although he lived a long time in retirement until May of 1829, I would not say that he had an especially happy retirement, and he was certainly very retired, unlike, say, Jefferson at Monticello. So there is a very quick version, and now we have a little bit of a slideshow of some images. So there's an image I especially love. That's the cover of my book, which is available in paperback, in Kindle. You can listen to it, and if you want to know more, it's a good place to start to learn about John Jay. It's amazing that this document has survived. This is his law license from when he first gets a license to practice law. This is the gentleman I mentioned, Enoch Crosby, this sort of natural spy who several times joined British regiments and then defected and told the Americans, and becomes the basis for the Fenimore Cooper novel. This is his commission as the first Chief Justice. I love that immense seal attached to it. This is courtesy of New York Historical Society. This is the side letter, or the circular letter. It's in Jay's handwriting with corrections by other people. And you can just see in all those corrections the kind of the midnight drafting process that this went through to get those last few votes for the U.S. Constitution.
Although I think that might not be the circular letter.
I'm sorry. Yes, I've got my screen too small. You're right. Sorry. Thank you for interrupting. These are the minutes of the first session of the Supreme Court.
Grand jury.
Yeah. Sorry. I need to abandon this and zoom a little bigger so I can see these slides better. This is kind of an unfinished portrait of the peace negotiation. The idea was that it was going to include both the British negotiators and the Americans. The British never sat for the artist, and so what we have are the Americans. From left to right, we have John Jay standing up there looking severe. John Adams, Benjamin Franklin, that's Henry Laurens, not quite finished. And then the one who looks to be George Washington is actually Franklin's grandson, who served as secretary of the commission. This, I think, again, correct me if I'm wrong, Judge Rosenblatt, do we now have the circular letter?
It's not circular, but it's there.
Okay. It's called a circular letter, by the way. I didn't know that term until I started doing these things, because it was intended to circulate among the states. It's not that it was it was sent, this is kind of the draft version in Jay's handwriting, and then this was printed up, published in the newspapers, but also was sent under a formal cover letter to all the other states. Among others who received it and was not real happy was the man we know as the father of the Bill of Rights, James Madison. He thought Jay was ill-advised to sign his name to this suggestion of amendments to the Constitution. This is the mural in the Poughkeepsie courthouse, which depicts the kind of compromise between the Federalists, who are on the right, that's Alexander Hamilton shaking hands, and the Anti-Federalists, who are on the left, led by the governor, George Clinton. Jay is just behind Hamilton. Jay was quite happy to let Hamilton get the credit for the compromise. He cared always more about the result rather than the credit. Another example of credit to Hamilton, this is the parade in New York City to celebrate the ratification of the Constitution. You note that the huge ship, which must have been quite elaborate to construct, is named the Hamilton, not the Jay. While he was governor, Jay got to live in a very nice house on the southern tip of Manhattan. It had been built with the intention that the federal government would remain in New York, but by this point it had moved to Philadelphia. He didn't get to live there the whole time because then the government moved up to Albany. Thank you very much. I think we now shift over to Judge Dillon.
Yeah, we'll hear from the other dimension of Jay's life, having heard about his life, his works, his political career. He was also the judge. And Justice Dillon is now going to acquaint us with the writings of someone who was the first Chief Judge of New York and the first Chief Justice of the United States Supreme Court. Justice Dillon.
Thank you, Al. And on behalf of Walter and you, Al, we want to thank the Chief Judge for her very generous introduction. She's been very supportive of the Historical Society and projects of this type. John Jay, of course, is the founding father from the state of New York that does not have a successful Broadway musical named after him. But Justice Rosenblatt may have some time in his semi-retirement. We have high hopes that maybe he'll complete that circle for us. So before talking specifically about Jay, I'd like to talk about the institution of the early Supreme Court. The Supreme Court, under the initial Constitution and the Judiciary Act of 1789, consisted of 6 Supreme Court judges, a chief and 5 associate judges. We might think that somewhat odd because it's not an odd number where there'd be a tiebreaker vote, but there was a method to the madness in the way the founders came up with that number. In those days, there were 3 circuit courts. There was the Eastern Circuit, which was New England and New York State. There was the Southern Circuit, which was Virginia on down. And then there was the Middle Circuit with everything in between. So the concept was that there would be 2 Supreme Court judges designated from each of the 3 circuit courts or circuits, which would total out to 6 justices on the Supreme Court. Also, the circuits in those days, unlike the practice today, did not have any dedicated circuit court judges. Instead, the circuit panels, which were originally 3 judges and then they reduced it to 2 judges, consisted of initially 2 Supreme Court judges, plus the judge of the district court in the state where the circuit was sitting. And when the circuit was reduced from 3 judges to 2, then it consisted of 1 Supreme Court judge and the district court judge. The Supreme Court judges were obligated to hear Supreme Court cases during February and August of every year. And they spent most of the rest of the year, when they weren't handling Supreme Court matters, riding the circuits. And then we get that phrase, riding the circuits around the country, hearing matters as circuit court judges. Now, there's an anomaly here that many of you might have just picked up on, that if you have a 2 or 3 judge circuit panel hearing circuit court matters that include the district court judge of the district from which the appeal is coming up, it means that the district court judge would be sitting as an appellate judge reviewing his own lower court decision. And by the same token, under this procedure, if you had 2 or 3 judge circuit court panels, which included Supreme Court judges, and those cases were then appealed further up to the United States Supreme Court, the Supreme Court judges would be sitting in judgment on their own lower court, circuit court decisions. Believe it or not, that anomaly wasn't rectified until 1896. But it was what it was for its time. If you had an appeal to the United States Supreme Court with 6 judges, and you were the appellant, a 3-3 tie would do you no good. You needed to have a majority of the court in order for there to be a reversal. So you needed to get 4 judges in your favor, at least, in order to get that reversal. So if you had a situation where you had a 3-judge circuit panel, 2 of those judges were Supreme Court judges now reviewing their own work, it would mean that in order for you to win your U.S. Supreme Court appeal, you would have to get 4 out of 4 votes of the remaining members of the court. or you would have to convince one or two of the judges that already ruled against you at the surrogate court that they were wrong and should rule the other way as justices of the Supreme Court. As practitioners, you probably get the sense that appellants would think very long and hard about ever appealing any matters under those circumstances to the U.S. Supreme Court, because the mathematical odds would already be stacked against you in many cases. The judges who would travel around the country riding the circuits uniformly hated the travel. There were no Marriotts. They had to ride on horses. You shared rooms and oftentimes beds with total strangers. The food was not always the greatest. You were away from your family all the time that you were traveling. You traveled in the heat. You traveled in the cold. You traveled in the rain. You traveled in the snow. You didn't have air-conditioned cars and trains, or heated cars or trains. And you didn't have Westlaw or law libraries at courthouses. So as a judge, if you're riding the circuit or going to the Supreme Court, you were expected to take your own law books as your own personal law library. You had a traveling library. When John Jay was selected to be the first Chief Justice, he had the stature to be the Chief Judge. He had been an experienced attorney in New York. He had set up the New York State court system from scratch when he was the first Chief Judge of what was then known as the New York State Supreme Court of Judicature. He had a lot of national stature from having been one of the negotiators of the Treaty of Paris, which ended the Revolutionary War. We saw that photograph, that drawing, I should say, the unfinished portrait of the negotiators, up with the likes of John Adams and Benjamin Franklin. That treaty was very, very popular with the people of the United States back then. And John Jay was a political rock and roll star at the time as a result of that. And he had the confidence of George Washington, because when John Jay acted as a spy master during the Revolutionary War, that apparatus uncovered a plot which is believed to have had as its goal the killing of General Washington. So those are the types of ties that bind. And John Jay and Washington seem to have been on good terms with one another. When he was nominated to be the first Supreme Court judge, he was approved by the United States Senate unanimously. Imagine that these days, if anyone from either political party were to be nominated to the United States Supreme Court and had a unanimous vote out of the United States Senate. He also had a diplomatic background, and that helped him negotiate consensus amongst his fellow judges. Appellate courts are unique in that it's decision by committee. You have panels of judges, and the judges try to reach consensus where and when they can. Of course, there will be occasions when somebody feels the need to dissent. But of the 11 cases that were decided by the Jay Court between 1789 and mid-1794, before Jay went off to London to negotiate the infamous Jay Treaty, of those 11 cases, 8 of them were unanimous. And of the 3 that were not unanimous, there was only one dissenting judge. Now you compare that with the following year when Jay was in London negotiating the Jay Treaty. The unanimity and consensus of the Supreme Court fell apart to an extent. There was one case in particular called Brigham versus Cabot in 1795, and there were 4 separate independent issues on appeal to the U.S. Supreme Court in this Brigham versus Cabot case, each calling for a separate vote on each issue. And the votes were on issue number 1, 3-1, on issue number 2, 2-1, with one judge not ready to vote. The third issue was a 3-1, and the fourth issue was a 2-2 tie. And the judges that were in dissent weren't always the same ones that were in dissent on this case. You had some rotation of who was in the majority on one issue and who was in the dissent on another. But turning now to John Jay a little bit, the first session of the United States Supreme Court was held on February 1st of 1790 at the Royal Exchange building in Lower Manhattan. It's at the end of Broad Street. There were no cases heard that day because none had yet been filed under the court's original jurisdiction, and none had yet had an opportunity to come up from lower courts through the pipeline. So the first session of the court was basically administrative in nature. The judges did not wear any robes. There was one judge of the Supreme Court, not Jay, who showed up that day wearing a white wig. And it's reported that as he was coming to the building or coming into the building, he was ridiculed by some people who thought he looked ridiculous wearing this white wig. And at no time sitting on the bench did the Supreme Court judges thereafter ever actually don the white wig the way the Brits did as part of their tradition. And also during that first session, they created a court seal, they appointed a court clerk, they swore in some attorneys. Being first is not always the easiest at something. And Jay was the first Supreme Court judge. And because these guys were inventing, and I say guys because there were no women judges in those days, there were a lot of legal principles that we take for granted today, legal principles that we consider to be second nature. But a lot of the principles that they encountered at the Supreme Court and elsewhere in the federal court system back in the 1790s were not established and were not second nature. And those wheels needed to be invented. And a lot of the decisions, you can look back and you can look at the results and say, well, of course that's the result. Well, we say that because the result is so second nature to us. There were decisions that were being made by the Jay Court in the 1790s where the results weren't all that easy or all that obvious because they were the first at what they were doing. One case that I'd like to talk about that illustrates this point is a case called West versus Barnes. It also happens to be the very first case that the United States Supreme Court ever actually heard oral argument on and then rendered the decision. It was heard in August of 1791. The national capital had moved by that time to Philadelphia, so the arguments were in Philadelphia. And the case came up through the circuit court of Rhode Island. I don't want to go too deeply into the underlying facts because the case was ultimately decided on procedural reasons, but the facts were as follows. There was a farmer up in Rhode Island by the name of William West. He was very well regarded. He owned a lot of farmland, but he owed a mortgage on that farmland. He owed 1,593 British pounds, in fact. And in those days, if you were going to pay a loan back to a creditor, you could do it one of two ways. You could either pay back the money in gold or silver coin, which was legal tender, or you could pay it back in the paper currency that was issued by your state. However, in Rhode Island, between the years of 1786 and 1789, the value of Rhode Island's paper currency devalued by 90%. So if you were a debtor and you were going to repay a debt, you would want to do so in the almost worthless paper money. But if you were a creditor, you would want to be paid back in gold or silver coin, which retained its value. William West wanted to pay back his debt. The creditors were family members named Jenks, Jenckes, and some in-laws. And they rejected the repayment of the loan that they had made to West using the paper money on the ground that that paper money had lost so much of its value. Back in those days, there was a law on the books in Rhode Island that was very farmer-friendly, not so much merchant-friendly. And it provided that if you were a debtor and wanted to repay your debt, and if your creditor refused to accept your paper money, it was a procedure where you could go to the state superior court and pay the money into the court. And a return date would be established for the creditor to come and take that money. And if the creditor didn't show up and take the money from the court, the money would revert to the state coffers of Rhode Island, and the debtor would receive from the court a certificate verifying that the debt has been satisfied, and that would have legal importance going forward. So William West took the money that he wanted to pay to the Jenks family, and he paid it into the Superior Court in Rhode Island. A return date was set. Nobody from the Jenks family came on that return date to collect the money. The money reverted to the state. William West received his judicial certificate that the debt was satisfied, but that wasn't the end of the story, because the Jenks family then sued William West in the federal court, in the circuit court. The circuit courts in those days had original jurisdiction to hear matters involving more than $500 of controversy. This case qualified for that, as well as diversity of citizenship. There was a member of the Jenks family by the name of David Leonard Barnes, who was Harvard educated and who actually lived in Massachusetts. He was an attorney, and he was the one that commenced on behalf of the family the case in the circuit court, relying on his Massachusetts residency for the diversity of citizenship and, of course, the value of the case. And he claimed that that the family was entitled to the money. And the argument that was made was that between the time that West filed or posted his money with the state Superior Court and the time of the return date when that money reverted to the state, the Rhode Island state legislature had suspended that law, so that the certificate William West received from the state court at the end of the state process was itself void. The law underlying it had been suspended by the legislature. So the Jenks family had a very good, strong, credible argument that there was no valid certificate of payment and that they were still entitled to payment of the full debt. William West was beside himself because he was facing ruination. He had paid the full amount of the debt and paper money into the court. The state wasn't going to give it back. The state was virtually bankrupt and had sovereign immunity from lawsuits anyway. And B, he was now expected to repay that same debt a second time in gold coin or silver, as was being demanded by the Jenks family. So today we have a process where if you want to appeal something, you have to file a notice of appeal. William West lost his case for the reasons that I've just discussed in the circuit court, and he wanted to appeal. In those days, you had to file a document akin to a notice of appeal. They called it a writ of error. And one of the things that a writ of error accomplished is that it orders the transfer of the file and record at the lower court to the higher court, so that the higher court could use it in determining the appeal. The Judiciary Act of 1789 provided in Section 14 that federal courts would issue writs of error, and I'm quoting here, necessary for the exercise of their respective jurisdictions and agreeable to the principles and usages of law. Close quote. Now, that term, agreeable to the principles and usages of law, really is a reference to what was the practice at the time for writs of error. The practice at the time, both in Great Britain, which we borrowed from often for legal principles, as well as in the states around the United States, was that only the higher court would issue writs of errors to lower courts to have the files transferred, because only a higher court can order a lower court to do anything. Writs of errors not be issued from a lower court because they don't have the authority to tell the Supreme Court to take a case or what to do with that record. But the Judiciary Act had a major flaw. It required that the writ of error be filed within 10 days of the decision being appealed from. Now remember, the capital at this time was in Philadelphia. So that if you lived in a far-off state from Philadelphia, such as Rhode Island, such as New Hampshire, such as Georgia, it was virtually impossible, if not actually impossible, for anyone to be able to travel by horseback to Philadelphia to obtain your writ and preserve and perfect your appellate rights. People that lived closer to Philadelphia didn't necessarily have that problem. But if you're far enough away, even if you started on the first day, and perhaps you don't start on day one, but people, as a practical matter, wouldn't be able to get to Philadelphia in time to file their writs. But in any event, the file got transferred from the circuit court to the Supreme Court. The Supreme Court docketed the matter. And on the day the case was called, in the August of 1791 term, in come an attorney representing the farmer William West. His name was William Bradford. He was the Pennsylvania Attorney General. Nothing in those days prevented high elected officials who were lawyers from also going into court and representing private clients. And also showing up that day was the Massachusetts Harvard-trained lawyer by the name of David Leonard Barnes, all of 31 years old. He had won his case in the circuit court in Rhode Island, and he went down to Philadelphia to argue the case and was sworn in to the Supreme Court to argue the case in August of 91. So when the lawyers were in front of him right off the bat, John Jay says to the appellant, to West, "Do we have any jurisdiction to hear this case?" There was no writ of error issued here by the clerk of the United States Supreme Court. The writ of error instead had come from the circuit court. The question, of course, being the real importance of it, if the writ wasn't properly executed, the Supreme Court would have no jurisdiction, and if the Supreme Court had no jurisdiction, the case would have to be dismissed for this very basic reason. Ultimately, the court did, in fact, dismiss the case for lack of jurisdiction without reaching the merits of the case. In doing so, the Supreme Court, which was 6-0 on this case, relied on what it believed to be the plain language of Section 14 of the Judiciary Act of 1789 about the common practices and usages, which was understood at that time as meaning that the writ would have to be issued from the higher court rather than from the lower court. The judges were very torn with this result because certainly there was no real prejudice by the procedures that had been used. Certainly William West should be entitled to some forum, assuming he can properly navigate the procedures to have his case heard. And the man was, after all, facing financial ruination. And if I skip forward a little bit in the history, he ended up going to debtor's prison. He lost the property and died in destitution. For us, a court relying upon the language of a statute is no big deal. That's what judges are expected to do. But then it was a big deal, because I'd like to pose a question. Suppose the Supreme Court had decided this case the other way, to disregard what they believe to be the plain language and understanding of Section 14 of the Judiciary Act. It would have meant that judges could disregard the language of a statute in order to reach some other result that they think makes more sense. They could, in effect, change the language that is enacted by a state legislature. You could twist to the breaking point statutory language in order to reach feel-good results. As practitioners, what would the effect of that been over the next 230 years? Clients come to you, they want advice, they want to know what they can expect, and you as lawyers have to be able to give them some predictability about what a court should be expected to do in giving your advices to the client. That becomes, I would say, impossible if judges can basically do whatever they want and not feel tethered to the language of statutes. So this was a big case for its time. It defined a separation of powers, that the legislature passes the law, that the judiciary applies the law, but that if the law has an obvious flaw, even one to the point of absurdity, as had occurred in this case, the fix is for the legislature to correct its language, change the law. And in fact, the following year, as a result of various pressures, including letters from Supreme Court judges, U.S. Supreme Court judges, the legislature did in 1793 amend the Judiciary Act to provide that from that point forward, the writs of error could be issued either from the lower court being appealed from or the higher court being appealed to. But that was of no help to William West, because that amendment was prospective only, not retroactive. I think we have been fairly blessed in the many decades since 1791 that from the get-go, from the very first case at the United States Supreme Court, we don't have judges acting as uber legislators. The legislatures are the ones that provide the statutory language, and the courts are bound by them. It doesn't mean that there isn't some wiggle room in the event that the legislative language is ambiguous or gray areas. There are first impression issues, but that was not the case that was here. Allison Moray, we have some more photos that I'd like to present at this point. This is the cover of my book. It's in hardcover only at this point, but there will be a softcover version released on September 2nd. Next photo. This is the oath of office for John Jay becoming the Supreme Court Chief Judge of the United States Supreme Court. Notice the quality of the handwriting there. For any of you like myself who were ever taught handwriting by the nuns in Catholic elementary school, you can particularly appreciate this. Next photo. This is the official portrait of John Jay. There's one hanging over the center of the courtroom behind the judge's bench in the most prominent position at the Court of Appeals in Albany. Judges did not have any official regalia back in those days. And for this portrait, in order to provide some panache, perhaps, some regality to it, Jay wore robes that he had received when he had earlier received an honorary degree from Harvard University. That might explain some of the reddish color. Jay did not sit for the entirety of this portrait. He sat for the head, and then a relative stood in for the rest of the portrait. The portrait was by the very famous painter Gilbert Stuart. Next photo. This is the Royal Exchange Building, where the United States Supreme Court held its first session ever on February 1st, 1790 in Manhattan. Next photo. I had mentioned that the judges riding the circuits had to travel with their law libraries, and this is a barrister bookcase that is currently located at the Jay Homestead in Katona, New York. All or most of you are familiar with these. You see them in law offices to this day. They're stackable compartments. The idea originated in the 1700s. You can take each compartment off and you flip, there's handles on the side of these. You flip each compartment onto its back so the glass is facing up, and then you can transport the bookcase with the books inside without ever having to remove the books. And then you reassemble them in order at your destination. Next photo. This is a photograph of the William West farmhouse in Scituate, Rhode Island. Of course, photography didn't exist until several decades later, the mid-1800s. So this isn't a contemporary photo of West's home when he was living there in the 1780s. But this building still exists. It's today at the corner of a very busy intersection in Scituate. Next photo. This is David Leonard Barnes of Massachusetts, who won the very first oral argument at the United States Supreme Court. I mentioned he was only 31 years old at the time. Next photo. The first arguments at the Supreme Court were in Philadelphia in a building known as Old City Hall. If you ever have visited Independence Hall in Philadelphia, which is a large brick building, to the very left of that is another more square brick building. That is Old City Hall. And this is the courtroom that has been preserved where many of the Supreme Court arguments were heard in the early, during the Jay period. And I think we have one more photo. Walter Starr had mentioned that Jay had negotiated the Jay Treaty. And when he came back to the United States, the terms of that treaty were very, very unpopular with many segments of the population. This is a drawing of Jay being hanged at the time in effigy. He went from being a rock and roll star, as I call it, after the Treaty of Paris, to being despised after the Jay Treaty. There's a quip that's attributed to John Jay. It hasn't ever been actually and historically established as being attributable to him, but it is said that he once quipped that as a result of the Jay Treaty, he could travel by horseback from Boston to Philadelphia at night, lit only by the light of his burning effigies.
So now this is really good. We're going to have a conversation between our two scholars, just freewheeling, open discussion to talk about the various aspects of their scholarship and about the life and work and decisions of John Jay. So let it roll.
Well, I just wanted to second something that Judge Dillon was saying about how kind of some of the most important things the Jay Court did were the things that it didn't do. So the Jay Court functions at a time of international tension. Britain and France are engaged in the 20-year Napoleonic War, and the US is trying to maintain neutrality. The Secretary of State at that time, Thomas Jefferson, as directed by the president, writes to the court and says, look, we've got some questions on which we want your advice. And Jay writes back first informally and then more formally to say, well, sorry, we're not in the business of giving advice. We decide cases and controversies. Again, to us, that's kind of second nature. You know, we instantly, when we see a case, think, well, does this party have standing? But at the time, it was far from obvious. The British, both the Chancellor and the Chief Justice of the British courts were, members of the cabinet of the government at the time. And so, giving advice was part of what, a Chief Justice did. But Jay, to his credit, and joined in this by all his colleagues, felt that was not an appropriate role for the justices of the United States Supreme Court. And I'm sure Justice Dillon can think of a few other examples of this. It's kind of paradoxical that in some respects, the most important thing you do as you get started are the things you don't do.
Yeah. I could jump in here, and we certainly want to hear about slavery at some point, but I could jump in here and talk a little bit about the Hayburn case, if that's all right, because that's an example that jumps to mind where the Supreme Court didn't want to do something. The Hayburn case rose out of a law that was passed by the Congress, which provided pension money to those who were injured as a result of the Revolutionary War and to their widows and their orphans. It was called the Invalid Pension Act of 1792. And the Congress put into the act the requirement, since there was no federal bureaucracy to really process these claims, that the Supreme Court judges, while riding the circuits, would meet with the applicants to assess the degree of disability and write a report and make some recommendations as to what percentage of the available money these pensioners should receive. And the recommendations were subject to review by the Secretary of War, and ultimately it was Congress that had the final say in every instance. Also, it's an example of a situation where there was no case in controversy, per se, as Walter had just mentioned. So there were all sorts of horrendous separation of powers and unconstitutionality issues that were at play here. And all of the Supreme Court judges, either publicly or privately, believed that this law was unconstitutional the way it was drafted. Jay publicly, along with William Cushing, Supreme Court from Massachusetts, believed that, well, perhaps the Supreme Court judges could act as pension commissioners, independent of their role as judges, and we could save the law constitutionally that way. But there was a decision from the Middle Circuit by Justice James Wilson and John Blair, where they refused to entertain the application of applicant John Hayburn. And the reason was that they believed that the law was, they didn't use the word constitutional, but they said that the law was defective. The public, the government officials, and the press all understood that to mean unconstitutionality. So an application was brought by Hayburn to the United States Supreme Court for a writ of mandamus to require the circuit court to entertain Hayburn's application. Now, bear in mind, this is now before the Supreme Court in 1792, 11 years before Marbury versus Madison. And if the United States Supreme Court were to decide Hayburn in a way where the Invalid Pension Act would be declared unconstitutional, the doctrine of judicial review would not be attributable, as we do today, to the 1803 case of Marbury versus Madison. It would be attributable to Hayburn. Jay, I suspect, was besides himself. The last thing he wanted to do in 1792 was to be part of a decision that would declare an act of Congress unconstitutional. For one thing, he believed in cooperation to the extent as possible between the various branches of government. But also, bear in mind that this constitutional fabric had only existed for 3 years, and the stability and future of this form of government that no one in the world had ever tried before was still uncertain. And I think the last thing he wanted to do was prompt a potential constitutional crisis between the branches of government. So he basically jumped through hoops to find a way that would prevent his court from having to hold that this law was so defective that it was unconstitutional. What he did was, when the case was originally brought to him in August of 1792, he adjourned the matter to the February 1793 term. And the reason for that, we believe, was to provide the Congress with the time that Congress would need to fix the constitutional defects with the law. And come February of 1793, what did Congress do? They fixed the problems with the law, the problems that various Supreme Court judges had identified to them in letters to George Washington and otherwise. So that when the Invalid Pension Act of 1793 was enacted, it rendered the writ of mandamus before Jay's court academic, and the motion was denied as academic. So it goes to Walter's point about how, sometimes the Supreme Court would come out with a principle and they'd be stepping on the gas, but sometimes they would handle a matter where they would be using a brake pedal. And this was a situation where they put on a brake pedal. They didn't want to go near the concept of judicial review. And that didn't happen until John Marshall, 11 years later.
Walter, may I ask you this? Inasmuch as John Jay was a consummate diplomat, can you identify some features of his role in shaping America's early foreign policy? Did he play a role in that, do you think?
Oh, sure. So even from the kind of earliest part of his tenure in the Continental Congress, he was on committees charged with foreign policy questions. Then as president of the Continental Congress, one of his duties, again, there's no State Department. So he's the kind of point person for the negotiations with their French and Spanish representatives in Philadelphia at the time. And he's kind of the point person for the discussions with them. And then he gets on a boat and goes to Spain. And it's very hard for us to imagine how far away Spain or France were at this time. I mean, obviously the geography hasn't changed, but it's 6 weeks, 8 weeks by boat, if you make it, and you might not. So there's really no possibility of, sending a note back saying, hey, I've come upon this issue. What do you think I should do? So, that's an important diplomatic assignment. Not a successful one, but I don't think that's really Jay's fault. People just didn't know very much about the Spanish situation until he got there. And then he has this incredibly successful stint of roughly another 2 years in Paris, negotiating the peace treaties that end the war. And then, if you actually go to the Wikipedia page for the list of secretaries of state, there's like a footnote, and the very first picture you see is actually that of John Jay as our Secretary for Foreign Affairs, because that's really the predecessor of the Secretary of State. He doesn't have the huge bureaucracy under him, but he has some very talented people. Almost all Americans know that Thomas Jefferson represented us in Paris, but you can certainly get people to pause long and hard when you ask them the question, to whom did Jefferson report while he was representing us as our diplomat in Paris? The correct answer is John Jay. And he also had John Adams in London. So he had some good folks on the ground. So yes, I mean, it would not be hard to argue that his diplomatic contributions were more significant, actually, even than his judicial contributions.
Yeah, in between judicial and diplomatic, there's something which maybe we call his actions as a drafter of iconic documents, and that he had a major hand in writing the Constitution of New York in 1777, 10 years before the United States Constitution. So here they are, John Jay, age, 33 or 34, Robert Morris and Gouverneur Morris and Robert Livingston, both 30 or under. What would it have been like for them to sit down and write a charter for a country that had come into existence with no template? No one had ever even attempted before that to write how a free country should be governed. Can you talk about that a little bit?
Yeah, one of my mentors when I was a young lawyer said that the start of any good lawyer's work is a bit of plagiarism. You need, as you say, templates, models, and there weren't many. New York was not the first out of the box in drafting a constitution. They did have, some of the other states had started a little bit before them, so they had those. And they had some, very strong ideas. In particular, they wanted to get away from this notion that the British had in essence, kind of one thing. The British had this concept of what they called king in parliament. They sort of fused the king and parliament together, and those were the legislatures. Jay, even from that very early stage, was very clear, we needed to have a governor, that was going to be the executive, we needed to have a legislature, they were going to make the laws, and we needed to have a judiciary. And paradoxically, although they were all incredibly young, they were also relatively conservative. They, compared to some of the other early state constitutions, the New York Constitution is a more conservative document. In that, for example, it does have a governor to execute the laws, and that is not the case, for example, in the first Pennsylvania Constitution.
Mark, you gave a wonderful illustration about how Jay felt. I think you put, he must hew to the statute, and tethered to the statute was your words, and the judges can't simply do whatever they want. Do you think, to what extent did that set the tone for the judiciary, that judges are bound by statutes and by legislative directive in addition to common law? Are there any other instances in which Jay shaped the jurisprudence of the country for decades and even centuries later?
Well, we could talk a little about the Chisholm case. Do you mind if I before we go there, Al, can I ask Walter a question about just following up on a point that he was making?
Of course.
About, Jay having been involved in the drafting of the state constitution, and other states were having constitutions drafted as well. The idea of having a constitution itself was kind of novel. Am I right about that?
Yeah, no, I mean, when the British at this time used the word the Constitution, what they were referring to was this sort of unwritten, nebulous set of concepts. But they didn't have a piece of paper. I mean, yeah, they had the Magna Carta, but that wasn't, when they said the Constitution, they weren't talking about just the Magna Carta. They had all sorts of ideas, and they had changed over time. I mean, the notion of what a king could do was far more limited in the time of George III, i.e. when Jay is writing the New York Constitution, than it had been at the time of Henry VIII. So yeah, just the very idea, which again, we sort of take for granted. I mean, almost every country in the world has a constitution. They may not pay much attention to it, as in, I don't know, the People's Republic of China, but they have one. It has all sorts of good principles. It's written down. And then, so the notion that every one of the new states should have one of these documents to set out these basic principles was itself kind of revolutionary. And Jay was very alive to how fortunate the Americans were to have been able to engage in this kind of a discussion and deliberation. In one of his Federalist letters, he writes about how blessed America is, that unlike most folks who just sort of inherit their forms of government from their fathers and grandfathers, that the Americans had the chance to kind of form their own governments through a deliberative process.
Yeah, the reason I wanted to explore it a little more is because I think that it also ties in with Al's question here, that if you are a John Jay or another founder and you write a constitution, you're not just writing your spouse, you're not sending a bill to a client, you're writing a constitution of all things. If you then find yourself a little later a judge, and the constitution you helped write defines what government is to do, what the legislature is to do, what the executive is to do, what the judiciary is to do, you probably go into your judgeship with a certain desire to adhere very closely to what the document says. And then that crosses over to the interpretation of statutes or the application of statutes passed by Congress. You're going to have a lot of respect for what the legislature writes, and not go off on your own tangent.
Walter, may I ask you this, and this ties in with a question, and I think it's of supreme importance that we not leave this unelaborated on, because it is so important. In Jay's role as a politician, can you elaborate a little bit on his role as governor in the abolition of slavery?
Sure, and I should go back, kind of way back in his lifetime. We have a tendency to think of slavery as a Southern institution and kind of forget that there were thousands upon thousands of slaves in and around New York City and throughout New York State at the time of the American Revolution. And the Jay family, like almost every wealthy family in New York City, owned slaves. But Jay, from a relatively early point in his life, is writing about how important it is to end slavery in America. So, for example, in one of his famous letters from, I think it's Spain, not France, but he writes to his friend who's in the New York legislature, and he praises a recent statute adopted in Pennsylvania to provide for the gradual end of slavery. And he says that, this strikes him as absolutely right. And moreover, he says that, until America comes into this, her prayers to heaven for liberty would be impious. He's the first president of the New York Manumission Society, which, as its name implies, is an organization encouraging people to give freedom to their slaves. That organization also is kind of what we would call a pro bono legal defense fund for Blacks who are accused of being fugitive slaves or find themselves in other legal difficulties. So long before he's governor, he's already, and indeed when he's running for governor, there's some negative comments that, we don't want to elect this Jay fellow because he's determined to to deprive the Dutch farmers of New York of the property they hold most dear, paren, their slaves, end paren. So long before he's governor, he has this anti-slavery reputation, deservedly so. And while he's governor, New York finally, he'd been pressing for this for a long time, but it finally adopts a bill to provide for the gradual end of slavery in New York. I mean, from the perspective of those who were slaves, it was far too gradual. But he has the pleasure of seeing it happen. Those who are interested in this subject, I talk about it some in my book, but there's actually a brand new book called Liberty's Chains by Professor David Gelman, which is all about the Jay family and slavery. And it goes all the way back to Jay's grandfather, who was a Huguenot merchant, and Jay's father, Jay himself, Jay's son, William, who's a judge, Jay's grandson, John Jay II. It's a really interesting, complicated story because, it's hard to know what to make of a man like John Jay, who writes so eloquently about the evils of slavery and yet owns slaves himself into the early 19th century.
Well, I think we cannot forget that we had slavery in New York for 150 years before John Jay stepped in as governor in 1799 and took the first step toward its abolition. And also that his son, William Jay, was an ardent anti-slavery writer. And the grandson, John Jay II, represented the enslaved in the Lemon slave case. So the Jay family, like others, when slavery was pretty much universal, were among those to turn the tide. Would you agree with that?
Yes. Jay uses some of his immense national reputation to argue on behalf of the slaves and on behalf of the legislation to gradually, again, it's very gradual at first, end slavery in New York State. But by the time Jay finally dies, the last few slaves in New York are getting their freedom.
Yeah, so what was the year of his death?
1829.
Right, sure.
He actually, amazingly, he lives to see Andrew Jackson inaugurated as president. I mean, it's just mind-boggling, the changes from his birth in this, tiny, it's really almost a village, New York City, to the time of his death, when, the United States is headed out here towards the Pacific.
Yeah. So he died in 1829. That means he lived to see in 1827, July 4th, 1827, final act of abolition in New York.
Yeah.
That's quite remarkable. Yeah.
I think he was very, very sincere and torn about the whole, the fact that he was a slave owner on the one hand, but very much an abolitionist on the other. And when he had been president of a manumission society, and when he became the Chief Justice of the United States, he resigned that role. And I can imagine that the reason for that was that he was hoping he'd get a slave-related case and didn't want to have any kind of conflict of interest. As it turns out, during his years on the Supreme Court, he never had any such case. But years later, when he was governor, one of the first things that he went to work on, it took him 3 or 4 tries, but he kept going back to the well to try to get some anti-slavery legislation enacted in New York.
And finally did. Yeah, there's another dimension of this I think very much worth talking about, and that is, if there is a single iconic work in the United States of literature of political science, it's the Federalist Papers. And we know that Jay and Hamilton and Madison were the authors of those Federalist Papers. Can we have some discussion about that and Jay's role in it and the Federalist Papers in general from the two of you?
Sure. So it's hard for us to imagine how controversial the Constitution was. You know, it was drafted in secret in Philadelphia, so no one knew what it was going to say until it appears in the newspapers. And pretty much from the moment it appears in the newspapers, there's an ardent opposition. And not long thereafter, there's a dinner party at the Jay household at which the guests include Hamilton and Madison. And I believe, I can't prove it, that at some point that evening, the three of them sort of pulled aside and, you know, said to one another, hey, we need to do something to ensure that this Constitution gets ratified. And they started writing this series of newspaper articles. I think it's really important to remember that they didn't set out to write a book. They set out to write newspaper articles in the heat of a political campaign. I've just been involved in one here. So I know what this is like. You know, you've got the newspaper printer breathing over your shoulder saying, damn it, you know, you have 5 more minutes, finish. And in the end, they did write a book. I mean, it's you know, 70 plus essays, and Jay doesn't write that many of them. Partly it's an issue of his health. He falls sick early in the process. But I think it's also that when he got back on his feet in early 1788, Hamilton and Madison were doing so well that he didn't want to kind of upset the chemistry. And so he writes one more, but he turns his pen to another wonderful document, a more general argument. You know, the Federalist goes kind of almost section by section through the Constitution, and that's what's made it such a great resource over the years, is the, you know, the fine detail. I mean, you want to know about the role of the Senate in ratifying treaties, well, you know, you can turn to the Federalist. Jay's latter essay was a longer essay that basically just sort of pulled back and said, hey, look, if New York doesn't ratify this Constitution and the new government gets started with New York as an outsider, where are we going to be? And those are similar to the arguments that he makes at Poughkeepsie, in which he over and over again kind of reminds people of the recent history of how they fought as a band of brothers against the British, and how they shouldn't leave this band of brothers as it starts the new adventure of the new Constitution.
We have an interesting question from one of the folks who just put it on the chat board. I'm going to read it because it's a little bit complicated. He says that he asked that in Hayburn's case, or any other comparable cases, did the Jay Court ever indicate that if it were to invalidate an act of Congress, would the effect of that decision be limited to the parties to the case, or would it extend to striking down or voiding or erasing the law from the statute books for all potential parties? He then goes on to say, great discussion to you two. Okay. So
I think I'm gonna punt that to the man in the robes.
If Hayburn had gone the other way, where the United States Supreme Court were to say we deny the mandamus because the law is unconstitutional, then that would have had to have had an effect, a cascading effect, on all the other similarly situated cases. And so I don't think that it was a situation where they would have been able to somehow limit the decision just to Mr. Hayburn and not have the same impact on everyone else.
what do you think Jay would have felt about John Marshall's? What if Jay read Marbury and Madison? Would he agreed with Marbury, the Marbury case? Do we know?
Well, he was very much alive. He didn't, unfortunately, in his retirement, he didn't provide us with lots of, you know, line by line commentary, but I'm almost sure that he agreed with Marbury versus Madison. Indeed, you know, Marshall only becomes Chief Justice because John Jay, at the very end of the John Adams presidency, declines a nomination to return to the court as Chief Justice. Adams nominates and the Senate confirms Jay as Chief Justice. His commission arrives, signed by none other than Secretary of State John Marshall. And he sort of thinks about it for a couple of days before writing back to President Adams, declining the appointment, coming back to what Judge Dillon was talking about, talking mainly about circuit riding and saying, look, I'm just not up to circuit riding. And also, he felt that the failure of Congress by that point to have done something to alleviate this burden of circuit riding reflected disrespect on the court. And so if he rejoined it, that he would in some way be kind of indicating his approval of the current system. But no, I think, I believe that Jay, not only Marbury, but he would have agreed with almost all the decisions of Chief Justice Marshall. I mean, they shared the same kind of federalist nationalist views.
Yeah, I agree with.
Yeah.
If I could just jump in now, I agree with everything that was just said, but I think that as far as the Hayburn case being used as a vehicle for judicial review, I don't think it was so much whether or not judicial review is a right concept or a wrong concept. I think that with Jay, he was probably concerned about the timing of it at that early time in the nation's existence. There had been on the state level some state courts that had recognized judicial review and found certain state legislation to be unconstitutional. And in most of those instances, what the legislatures of those states would do would simply ignore the court.
Well, and
they
that's
didn't
what
want to
happened
put the court in that position. Yeah.
And that's what happened in New York as well. The first Constitution had this bizarre thing called the Council of Revision, composed of the governor and the Chief Justice and a couple others who were supposed to review New York laws for constitutionality, and Jay had participated in that. And on a number of occasions, what happened was what you just said. You know, the Council of Revision considered it and put out a detailed explanation of why the law was unconstitutional, and the legislature just ignored it. And so he had not only the experience in other states, he had experience right in New York of a legislature that was just, you know, not inclined to listen to constitutional quibbles.
We have a couple of hundred people watching, and not every one of them is expert in appellate law and what we mean by judicial review. So I just thought I would just elaborate for a moment on the importance of the concept that judges can invalidate actions of the first branch of government, of the Congress. In England, they don't recognize the power of judges. They believe in parliamentary supremacy. And so that's why it's important that we're talking about the notion that established under Marbury in 1803 or 1804, that judges can invalidate legislation. But you think, Walter, and you think, Mark, that Jay would have agreed basically with Marbury against Madison in the concept of judicial review of legislation in the main?
I think probably.
Yeah, I think if he disagreed strongly, that it would have gotten into the record in some way. He would have written to a friend or something, and he didn't. So I think he agreed with that decision.
You know, you said something interesting. I hope I'm not telling any big secrets out of school, but before we went on the air, we had a chat, and Walter Starr said, we wish we had a record in 1798 or 1799 of what John Jay did to maybe twist some arms to create the first step toward abolition. Can you elaborate a little bit on that? I was intrigued by what you were saying along those lines.
Well, I very much wanted, as a biographer, I wanted to kind of have his fingerprints all over that first New York statute. But in those days, governors didn't, they didn't sort of send a whole agenda up to Capitol Hill and say, hey, do this. and so I could not find, I wanted to find some letter from an opponent of the legislation complaining about Jay's lobbying efforts. I didn't find it. Maybe it's out there somewhere. What his son, William, wrote about 25 years later, but bear in mind that William is at this time living with the aged John Jay. His son wrote that Jay realized that in the political situation, it was best for him to kind of stay silent and stay in the background. He didn't want to make it a partisan matter. And indeed it was, although this word didn't yet exist, it was what we would call a bipartisan bill. There were both the Federalists and Republicans voted for that bill in 1799.
That's interesting that both sides coalesced on that.
There were people on both sides who voted the other way, although I'm not sure that more than one or two Federalists voted against it. I think the Federalists pretty much lined up with their Federalist, I think, and then there were a number of the Republicans, particularly, think again about just what's happening in New York at that time. The whole upstate region is beginning to open up and be settled. There were very few slaves in places like, Rochester, Syracuse, Buffalo, etc. And so the legislators from those places, along with the folks from Manhattan who had always been anti-slavery, those were the folks who basically passed the bill over the objection of legislators from places like, the central Hudson Valley, which still had a very strong slave economy.
We have a question that I will repeat verbatim. Do you have any comments on the 1792 election for governor when Jay conceded to Clinton, even though the Board of Canvassers refused to count the votes from Otsego County that would have elected Jay? The reflection that the majority of the electors were for me, this is now a quote, is a pleasing one. That injustice has taken place does not surprise me. Having nothing to reproach myself with in relation to this event, it shall neither discompose my temper nor postpone my sleep. A few years will put us all in the dust, and it will then be of more importance to me to have governed myself than to have governed my state. So the question is about this 1792 election for governor. Any thoughts on that?
So that language you were just reading was a quote from a letter from John Jay to his wife, Sarah, as the votes are being counted, and in Sarah's view, utterly miscounted. I mean, she's far more angry about the counting and the political shenanigans that are going on than John is. And that quote is so John Jay. I mean, you can find dozens of quotes along those lines of, we live in a world in which, in many cases, the foolish, prevail over the wise, and we just have to be patient. And we have to, that reference to, hey, before long, we're all going to answer to our maker. And I want to be able to stand up straight and look him in the eye and have done the right thing. I mean, that is John Jay. When I was writing the book, when I started, my wife said, well, you have to find a love affair. If he doesn't have a love affair, no one's going to want to read the book. But
he had a love affair with his wife. They had a very strong relationship.
He did, but that wasn't. My wife was thinking of something more.
I get it, but yeah, she was the one that was really angry about the shenanigans with the vote counting the year that John Jay lost the governorship, because she wanted John Jay in New York, home with the family, not riding around the country on a horse hearing Supreme Court cases.
Yeah,
I suspect, if you don't mind my jumping in more, that 3 years later, because there were 3-year terms in those days, 3 years later, when John Jay was again on the ballot, people remembered the shenanigans, and it could only have helped John Jay win that election the second time around. Governor Clinton got the nickname the usurper because of the shenanigans that was attributed to him.
Why, I never heard that.
Yeah.
Mark, while we're at it, can you tell us a little bit more about Chisholm against Georgia? Can you elaborate on that? It's an important case, and maybe you can touch on it. But
I'll try to keep it short. Chisholm versus Georgia, in my opinion, is one of the most important cases that John Jay had at the Supreme Court. The Constitution had in Article 3, Section 2, some language defining the jurisdiction of the federal courts, and it included hearing cases between a state and citizens of another state. So the plain language of that pretty much says that somebody from one state can sue a different state from where they actually live. When the Constitution was being drafted, you had the Federalists and you had the Anti-Federalists. The Anti-Federalists wanted as little federal government and continentalism as possible. And they didn't like this language that was drafted, and they went to the Federalists. And people like Hamilton and Madison and Marshall, in very good faith, said to them, well, we agree with you that the states should not be subject to lawsuits in the federal courts, because after all, if a state loses a case in federal court and doesn't pay a judgment, how are you going to enforce it? You're going to go to a war against the state? We can't do that. So there was this gentlemanly understanding between the Federalists and the Anti-Federalists that the federal courts wouldn't be hearing cases against states. Now, the states owed a tremendous number of people money as a result of the Revolutionary War. And those individuals, of course, wanted to be paid, and they weren't getting paid. And Chisholm was the executor of a man named Robert Farquhar, who was owed money from the state of Georgia. He sued the state of Georgia in federal court. There was diversity of citizenship. And the case came all the way up to the United States Supreme Court. And the issue was, how do we interpret this constitutional language? Are states even subject to federal jurisdiction? The state of Georgia refused to participate in the case on the ground that they weren't subject to it. We have two main schools of thought for constitutional law. You've got originalist thought, and then you have, and it's developed in the last 100 years, that the Constitution is a living, breathing argument, and it's adaptable to changing times. Well, back in the 1790s, all you had was originalists on the bench. And we've discussed some of the reasons why these folks adhered very closely to the language of Constitution and statutes. But within the school of originalism, there's two wings on the same bird. One wing looks at what were the founders' intent, and one wing looks at what's the plain language, the textualism of the Constitution. And this Chisholm case exposes a difference between these two wings. Usually the founder's intent and the language are one and the same thing. But here you had this understanding between Federalists and Anti-Federalists that the states weren't subject to lawsuits in the federal court, and yet the plain language of the Constitution, plain language can be pesky things. It says that they can be, that you can have jurisdiction between a state and citizens of another state. So the J court had to choose up which wing of originalism they belonged to. And they came down, it was a 5-1 decision, Judge Iredell in dissent, but they came down on the side of the plain text of the Constitution, meaning that the state of Georgia was subject to, and all states were subject to, the jurisdiction of the federal courts. Now, this was going to open a floodgate of litigation against states. This was very unpopular. Think of an issue today, which is a hot button issue, gun control, Roe versus Wade, whatever. Back in the 1790s, people were really, really upset about the decision in Chisholm versus Georgia. The Georgia legislature was so mad that the lower house of its legislature passed a law. It didn't get enacted, but they passed it, that if you sued the state of Georgia, you'd be arrested and hanged without benefit of clergy. That's how angry people were. Massachusetts is the Commonwealth that really took the lead in proposing an amendment, an 11th Amendment to the Constitution to nullify the finding of Chisholm. It passed both houses of Congress by overwhelming numbers. It was ratified by 3/4 of the states as required, and was the first time that a constitutional amendment had ever been recognized beyond the original 10 amendments. That amendment was ratified by the last necessary state in February of 1795. The Chisholm case was I think 1792. So it was a very, very, in my opinion, a very quick change to the Constitution. One last footnote on this is that the 11th Amendment might not really be an amendment to the Constitution. There was a later case called Hollingsworth in 1798 that held that it didn't change the Constitution, it simply clarified and explained the language that was in the Constitution. Why was that an issue? Well, if it was a change in the Constitution, then the 11th Amendment would be prospective only. But if it was a mere explanation of the existing Constitution, well, then it would be retroactive.
Indeed.
And that was the significance. So it's sort of like when you go to a hotel and you're on the 14th floor, but it's really the 13th floor because there is no button in the elevator for a 13th floor. The 12th Amendment might really be the 11th Amendment, and then you follow the numbers from there on down.
So here's a question. I had not known this, but it sounds interesting. I'm quoting, Jay played around with scriptural themes, especially prophetic themes involving apocalyptic predictions. How did this shape his worldview involving both domestic and world affairs? Had you heard that, Walter?
Well, certainly he's a person who, in both his private letters and his public documents, is often sometimes quoting and sometimes just paraphrasing or alluding to bits of the Bible. And he does have this remarkable sense, objectively speaking, in the winter of 1776-77, the American odds are not good. When Washington is chased all the way across New Jersey and flees to the outskirts of Philadelphia, it looks like it's over. And Jay publishes a pamphlet at that point saying, no, God is on the American side, and we're gonna see this through. So he is a person who kind of both draws on his faith in private life, but is also not afraid to talk about his faith and kind of blend how should we say, his Christian faith and his American faith into one sort of kind of synthesis. And in his retirement years, he becomes, if anything, even more religious. He really spends just a lot of his retirement living very quietly, going to church on Sunday mornings up there in Westchester County.
Justice Dillon just pointed out that the 11th Amendment is there and it's important, but by and large, the states can be sued and are sued when they waive their immunity, and municipalities have uniformly done that with some conditions, so that today the 11th Amendment probably has little effect on litigation. That's Justice Dillon's point, which we can air to everyone there. Mark, do I quote you
in the chat
on that?
Yeah, I put it in the chat.
As a matter of fact, we even have a court called the Court of Claims, in which you can sue the state of New York, because New York has allowed itself to be sued, and Lord knows there are plenty of lawsuits. The appeals from the Court of Claims come to your court, right? To the Appellate Division, Second Department, and the other departments as well, right?
Yes.
What about Jay's involvement in the Citizen Janet affair?
So this is sort of both in your domain and mine. So Citizen Janet is this revolutionary French diplomat who arrives in the States and immediately starts trying to use the United States as a base from which to wage France's war against Britain. He's recruiting Americans to join the French Navy. He's fitting out ships to serve as privateers to attack British ships. And pretty quickly, Jay and the other it doesn't, they're not yet separate political parties, but those tending towards Jay and Hamilton's view come to view him as a pest. And so he sides with Hamilton in the dispute within the cabinet as to how to handle Janet. It was one of the rare instances in which I'm critical of Jay, because even as Chief Justice of the United States Supreme Court, he puts out a letter that kind of takes his side of the case rather than just sitting quietly.
Yeah. The ironic thing about the Janet affair is that by virtue of this letter that Walter just mentioned, which took issue with Citizen Janet or Minister Janet, subjected to perhaps defamation. And there is a clause in the United States Constitution that provides that if the defamation action involves a foreign ambassador or minister, I don't have the exact language in front of me, that the court of original jurisdiction to hear the case is the United States Supreme Court. So were there to be an action for defamation brought by Janet against John Jay, it would necessarily have to have been filed in the United States Supreme Court when and where John Jay was the Chief Justice. Now, you can't make that up, but that's the reality of the situation. And a brief story about why there never really was a defamation case, or at least not one that was followed through upon. Janet was working on it. He was assembling witnesses. He hired a lawyer. He was good to go with this. But the French Revolution was occurring. You had the death of Marie Antoinette and the execution of King Henry and Louis, I should say. And the Jacobins came in. Minister Janet had been appointed by the prior Girondin government of France. And George Washington had sent a letter to what was by then the new French government, wanting Minister Janet recalled back to France. France was happy to try to make their American allies happy, particularly given the war with Britain that was underway. So yeah, they were going to withdraw Janet. They did so. And they sent the new minister to the United States, who reminded Janet that under French law, if someone is a traitor to the country or an enemy of the state, that person's family can be executed. And Janet had family back in France. Janet wanted diplomatic immunity. He wanted asylum, I should say. And George Washington was not inclined to grant it. But then Alexander Hamilton had the brilliant idea saying, well, you can grant it, but the condition is that Janet not file any defamation suit against our buddy John Jay. And the deal was done.
Good. Well, Walter, in these exchanges, we speak of the lingua franca. Was Jay fluent in French or in Spanish? How many languages did he speak? And would these international diplomatic exchanges been by and large in French, you think?
His French was pretty good. As a boy, he was sent to a Huguenot school, a French-speaking school, and his French was, I think, pretty good. He never got much Spanish, but fortunately, French was the diplomatic language in Spain. So with his French and with translators, he did fine in his diplomatic exchanges.
I'm informed that we have about 5 minutes left. So how about some concluding thoughts from both of you that, what are your lasting impressions, your lasting thoughts that you can leave with the viewers?
I'll start. I wrote my book a long time ago, and I actually reread much of it to get ready for today. And in addition to noting some of my own errors, I was just struck over and over again by how much I like this guy. He's just, He's the kind of guy, if you were involved in a political problem or you were, 6 justices sitting around trying to figure out how to decide a case, he's the kind of guy you would want to have around the table. He was, calm, serious, diligent, just all the things that that we want to have in an American leader.
Wow, how well said. And everyone trusted him, or almost everyone trusted him. So it seemed. What a great virtue. Yeah. Mark?
I would conclude by saying that a hallmark of John Jay's life seems to be that when somebody needed him to do something important, he was a go-to guy. He never did great things for himself or for fame. He didn't care about fame. But if you needed somebody to be on a committee that would have to do with the Revolutionary War, he'd do it. If you needed somebody to go to the Continental Congress, he'd do it. If you needed somebody to go to Spain as a representative of the United States, he'd do it. Go to Paris, negotiate the Treaty of Paris, he'd do it. Come home, be the Secretary of Foreign Affairs, he did it. Go to the Supreme Court, he did that too. He got drafted to be governor of New York. Eventually, he reached an age and a point in life where he said, I've done enough. But his life is marked by a lot of travel, both in the United States and overseas, a lot of sacrifices away from his family to do all of the great things that he did. And the time when he finally said no was when, and Walter was talking about this, when John Adams came back to him at the end of the Adams administration and said, I want you to go back as Chief Judge of the Supreme Court. And Jay finally said, no, I'm going to retire.
And so he did. So we want to wrap up by thanking Marilyn Marcus, our executive director, and Dan Sierra, who helped on the technical side of things, and the ever helpful Allison Maury, who helped put all this together. And of course, to our 2 great scholars who made this so lively and interesting. And for those of you who are interested, I'm told that the video recording will be available on our website soon. And with that, we'll conclude. I had a good time, and it was just so informative and interesting chatting with our 2 scholars. And I hope the audience enjoyed it well for another presentation of the Historical Society of the New York Courts. Farewell, good night, be healthy, and be well.
Thank you.
Thank you all.